welcome, and thank you for joining us for this webinar brought to you by the Lawyers Committee for Civil Rights Under Law. My name is Jon Greenbaum, and I'm the Chief Counsel at the Lawyers Committee. We're going to get started with the program momentarily. We are going to give people a couple minutes to log on as we're giving some introductory remarks. As a reminder to those of you on Zoom, there's a question and answer feature at the bottom of your screen. Please submit your questions throughout the program. Finally, if you would like to receive updates about the work at the Lawyers Committee, please visit our website at www.lawyerscommittee.org. Thank you for joining us today. We will now get started with our program. And we're going to lead off with remarks from the President and Executive Director from the Lawyers Committee, Damon Hewitt.
Thank you, John, and good afternoon, everyone. As I shared with colleagues just a few minutes ago, I join you today in not the greatest of moods, quite upset, concerned, even angry at what the U.S. Supreme Court is doing to our country as currently comprised. We have seen the blows continue to come, and we're here today to talk about the end of the October 2021 term, but even before we get to the 2022 term, the blows continue. Just in the last few days, the Supreme Court wreaking more havoc in additional cases on voting rights. We are in a perilous position, my friends, as a nation, as a movement of advocates, of people of conscience. We are told, essentially, that states have rights, but people do not. We are told that you have rights, but you have no remedy. And sometimes in the case of Dobbs and abortion rights, you have no rights at all, at least not anymore. The US Supreme Court, for the first time in its history, eliminating a fundamental right, fundamental constitutional right. These are troubling times. Now, we know that we've come from tougher places in some ways. We know that there was advocacy before there were civil rights ever statutes, such as the Voting Rights Act of 65, the Civil Rights Act of 64, the Fair Housing Act, and what have you. We know there was advocacy before Brown v. Board of Education, legal advocacy. We know there were efforts even before the 14th Amendment, the Reconstruction Amendments even existed. So we know we've come from tough places in this country, and we understand the possibility and the promises of our democracy. But it is a gut punch when those promises ring hollow for people in tangible ways, when their opportunity, their potential prosperity, their health, their liberty, and their lives, our lives, are frankly on the line. Our expert panel today will take you to these tough places. We will analyze it as we do as lawyers, as scholars, as public thinkers. But we also are doing it, this analysis is coming from a space of real concern, from a heart space. Because if anything, we're not just attorneys, we're also a community of concerned citizens, concerned people. And we care about this country, and we care about the least of those, the people on whose behalf and for whose benefit this organization was founded, people of color in this country who are usually at the bottom end of oppression. So with that somber note, I want to turn back to John and our panel. I just thought it was important to frame the really heavy and difficult stakes where we're in. But one thing I can promise you, my friends, we will not give up. We will continue to fight every step of the way. And as we fight, we'll not just fight harder and stronger, but we will fight smarter, and we will fight together alongside you. Thank you.
Thanks, Damon. Look, this term for progressives and for people that believe in civil rights is the worst term in decades, with a lot of concerning issues to follow, given some of the cases that the court has already decided it's going to take up next term. I am going to start with something positive, because for the most part, for the time to come, we're going to be talking about things that are negative. And that is that we have a new justice on our Supreme Court. Justice Jackson, as has been said many times, is the first Black woman justice on the Supreme Court. And that is a moment that we should all celebrate and look forward to Justice Jackson doing her job in interpreting the Constitution and the statutes of the United States fairly and to the best of her ability. With that, I'm going to give a quick thanks to some of the people who helped put together this webinar today on our staff, Isabella, Violet, and Kate. Thank you for all your help in terms of putting this together. And now I'm going to briefly introduce our blue ribbon group of panelists before we jump into starting to discuss the cases. First, the Honorable Judge Shira Scheindlin, who, and you'll see their bios as we talk about them, and their bios are very short compared to their accomplishments, and my description of them is going to be even shorter. Judge Schindlin was a U.S. District Court judge for 22 years. And I'm proud to say that for the last 2.5 years, she's been a co-chair on our executive committee and board of directors. And then next is Deepak Gupta. Deepak is one of the leading appellate and Supreme Court advocates amongst progressive lawyers. He founded his own law firm a number of years ago, Gupta Wessler, which has quickly become a powerhouse in about a decade. And Deepak is also on the advisory board of our organization. And then finally, Dean Danielle Holley-Walker, who is currently the dean at Howard University School of Law and a leading thinker about constitutional issues. And Dean Holley-Walker is currently the vice chair of our board. And in September, she will become the co-chair of our board as Judge Schindlin steps off. So we're going to jump right into the cases. We're going to start with the 2 abortion cases for this term. I'm going to briefly describe each case, and then I'm going to turn it over to Judge Schindlin, and then we're going to have some panel discussion about it. So the first big abortion case of this term was Whole Woman's Health versus Jackson, which involved Texas SB 8 law. And what was novel about this law was that it had limited state enforcement. That in place of having the state enforcing this law, it created this bounty system where any individual could file a lawsuit against anybody who aided in an abortion. And so Whole Woman's Health brought a pre-enforcement challenge in front of the court, and the court, by a 5-4 vote in terms of the biggest issue in the case, found that the case could not be enforced against Texas state officials, and more or less foreclosed any sort of facial challenge to the statute, which basically sort of opens the door for states to enact statutes that are blatantly in violation of the Constitution. And that's okay, says the 5-member majority, as long as you don't have any state officials engaged in the enforcement mechanism. And then the second case, the big case that came down last Friday, is the Dobbs case. And this case involved a 15-week ban on abortions in Mississippi under the standard in Roe versus Wade. And then later in the Casey cases, you couldn't have an absolute ban prior to viability, which happens, roughly in the 23rd week in abortion. And the court did 2 things here. At first it decided by a 6-3 vote that the Mississippi law was in fact constitutional. But the more dramatic finding is that the court held 5-4, with the difference being that the chief was not part of the 5-member majority. The court held that there is no right to abortion under the Constitution at all. So it is an overrule of Roe and Casey, but even beyond the holdings in those particular cases, the finding that there was no constitutional right at all to abortion. Now I'm going to turn it over to Judge Schindlin to talk about the two cases before we have some panel discussion.
Well, thank you, John, and welcome to everybody on this webinar. I certainly did not draw an easy assignment today. These are complex cases, and I'm going to drill down and maybe even repeat a little bit of what John said, but I think you need to know the details here, so I'm going to do it. So obviously, let me start with the first one, the Texas one. There, certain abortion providers brought suit in federal court. They'd already sued in state court, but they brought suit in federal court to mount a pre-enforcement challenge to Texas's new law, which, as you heard, prohibited abortions after only 6 weeks. They called it the heartbeat law, and it was obviously unconstitutional under the then controlling Roe standard. Many defendants were named in this suit, including judges, court clerks, the state attorney general, and state officials who were involved in licensing doctors to practice medicine. All these defendants moved to dismiss. The district court denied that motion, thereby keeping the suit alive and to proceed against all those defendants. Well, an interlocutory appeal was taken to the Fifth Circuit, which denied the petitioner's request to enjoin this new law while they resolved the merits of the defendant's appeal of the denial of the motions to dismiss. So they said, we're not going to pause this thing while we sort out the motions to dismiss. The petitioners then sought emergency relief in the Supreme Court, which declined to disturb the Fifth Circuit ruling, thereby allowing this law to take effect. The petitioners then sought certiorari before judgment, bringing it back to the Supreme Court for a second time, and the Supreme Court took that cert petition. So here's the merits of it. The majority in the Supreme Court, you already heard it was 5-4. Justice Gorsuch wrote the opinion. Justice Thomas and Justice Roberts wrote concurring opinions. And of course, there was a dissent. But the majority there, the Gorsuch opinion, claimed that it could only review the defendant's appeals of the district court's order denying the motions to dismiss. So it said, we're not even going to address the question of whether this new law violates the federal constitution. Frankly, it just wanted to let this law, which I already told you and you all know clearly violated Roe, they just wanted to let it go into effect. In short, this was a really strong signal of what was going to come in Dobbs, which we're going to turn to. It held that petitioners could bring a pre-enforcement challenge in federal court to test this new law's compliance with federal law, but the law could go on while it played out. So my guess is, and I don't say this with too much disrespect, but the Gang of Five knew that by then Roe would be found unconstitutional, and so SB 8 would no longer violate the federal constitution by the time they got back to it. Now, 3 of the dissenters telegraphed their eventual dissent in Dobbs, which we're going to get to. But first, they focused on the fact that SB 8 was designed to avoid judicial review by ensuring that no state employee or official had the power to enforce the law. As you heard from John, only private citizens are empowered to do that. This was an obvious challenge to federal jurisdiction to test the constitutionality of the law. But actually, that strategy failed. 8 justices agreed that a pre-enforcement suit could be brought in federal court, but only against some of the named defendants, particularly the licensing officials who had authority to enforce the law against doctors who might violate the law. The dissenters, some of them, also thought the attorney general should be a defendant because he had coextensive authority with the medical board to address violations of the law. And the dissent would have even allowed court clerks to become defendants because they issue citations, they docket cases, and therefore the dissent said they're part of the enforcement scheme. The 4 dissenters stated, and this is a quote, "The clear purpose and actual effect of SB 8 has been to nullify the Supreme Court's rulings, but the Constitution is supreme and the judiciary interprets the Constitution," close quote. Well, further quote, "It is the role of the Supreme Court in our constitutional system that is at stake." And you need to hear that again. It is the role of the Supreme Court in our constitutional system that is at stake. In separate decision by Justice Sotomayor, she used exceptionally strong language. She said Texas acted in open defiance of the Supreme Court's precedent. She stressed the chilling effect on abortion providers and those seeking abortions because of the grave consequences of violating this law. Namely, anybody who violates it could sustain $10,000 in damages, attorney's fees, and by the way, they would face
we might be having, we had technical problems for a second there, but
Oh,
keep
okay,
going.
so I
Keep
think I'll
going.
pick up again with the consequences of violating this law. Could be $10,000 in damages, attorney's fees, and repeated suits. Even if you win once, they can sue you again and again. There's no preclusive effect. She wrote that the majority chills the exercise of a constitutional right and aims to evade judicial review. And the failure of the Supreme Court to enjoin this obviously unconstitutional law at the time she wrote will encourage other states to adopt similar law, which is exactly what happened. She wrote, providers face calamitous liability from a law that is clearly unconstitutional. And she said, this madness should have been stopped long ago. She noted that the state conceded the petitioner would have to a federal forum would be to violate the law, forfeit all of their rights in state court, all of their procedural rights, and then at the end of the day, ask for federal judicial review, including the discretionary cert, which they may not get. She called this a brazen challenge to the federal structure. The state is nullifying federal law. This scheme targets, she said, the exercise of any right with which Texas may decide to disagree. She wrote, the court leaves all manner of constitutional rights more vulnerable than ever before to the great detriment of our Constitution and our republic. Justice Roberts, just 3 little quotes. He said, the clear purpose of this law is to nullify the court's rulings. If states annul the rulings of this court, the Constitution itself becomes a solemn mockery. And finally, it is the role of the Supreme Court in our constitutional system that is at stake. So that's the short summary, important summary, but it's an attack on the Supreme Court and its ruling, but that's the way it is. Now, you want me to go right on to Dobbs or stop for a moment with SBA? Go right on to Dobbs, John, what would you like?
Go ahead. Go right
ahead.
on.
Okay, so you all know by now, opinion authored by Justice Alito, the Supreme Court overruled Roe versus Casey. Actually, as John said, the overruling is 5-4, but the bottom line was 6-4, and held there is no longer a constitutional right to obtain an abortion, period, full stop. As Damon told you, this was the first time that a court has taken away a fundamental right that we've all had for 50 years. The reasoning of the majority can be awfully briefly summarized. Abortion isn't mentioned in the Constitution, they say. It's not part of the original meaning. The notion of liberty in the 14th Amendment Due Process Clause doesn't cover bodily autonomy, intimate personal matters, or privacy. And the right to abortion was never firmly rooted in our nation's history. So accordingly, they found there's no basis to find a right to an abortion in the Constitution. Because of that, there's no right, but therefore we default to the people and their elected representatives, which means, practically speaking, state legislatures. Now, you all know about state legislatures these days and how they're formed, and we don't have time to go in that, but it's not a great place to hope your rights will be enforced. All of you on this call by now have read editorials, op-eds, guest essays, and talking heads on TV, so you all know the contours of the reasoning. And you all know the other rights that are now at risk, despite Justice Alito's disclaimer that Dobbs only applies to abortion rights and to no other rights. This is a one-way ticket, it's today only. Well, Justice Thomas in a concurrence explicitly said that substantive due process is a fiction, and all decisions based on that theory should be revisited, which include the right to contraceptives, sex between same-sex consenting adults, and gay marriage. it would not surprise me at all that cases challenging those rights will quickly be brought, and one or more will make their way to this Supreme Court. So it was a pretty tough assignment to decide what can I add in the way of analysis to all of this that you've heard. So I focused on a couple things that were most significant to me. I want to begin with a shout out to the Lawyers Committee, whose amicus brief in support of abortion providers was cited twice in the strong group dissent authored collectively by Justices Breyer, Sotomayor, and Kagan. In the first cite, the Lawyers Committee brief is cited for noting that in Mississippi, 19% of women of reproductive age are uninsured, and 60% of Mississippi counties lack a single obstetrician gynecologist. These facts, these statistics supported the dissent's rebuttal to the majority's view that overturning Roe is justified in part by changes in laws relating to healthcare coverage, pregnancy discrimination, and family leave. But the dissent noted that many women do not have adequate healthcare coverage, or healthcare services may not be geographically available. And while I'm doing a shout out, I have to say the Howard Law School brief, Dean Holley-Walker's law school, is cited for noting that bans on abortion increase maternal mortality by 21%, with white women experiencing a 13% increase in mortality, but Black women experiencing a 33% increase in mortality. In other words, childbirth will now be a greater threat to women's health because of the absence of abortion rights. The second citation to the Lawyers Committee brief notes the geographic and financial barriers that women face in obtaining effective contraceptives. This footnote supported the dissent statement that even the most effective contraceptives fail. And effective contraceptives, by the way, are not universally accessible. The point made by the dissent was to stress the reliance interests in maintaining Roe that the majority rejected by simply noting that pregnancy is generally an unplanned activity. And so the court said, we're not going to consider intangible forms of reliance. In my just couple more minutes remaining time, I want to focus briefly on the strength and reasoning of the dissent and the majority's obvious lack of respect for Starry Decisis and the dangers that that presents. So let me start with the dissent. They said the balancing of the competing goals of protecting fetal life and allowing women to control her own body is now gone. So that balancing test that Casey enshrined is just wiped out. Instead of balancing those interests, the court now holds that a state can ban abortion completely if its state legislators pass such legislation. And it can be a complete ban without a single exception for the life of the mother, rape, incest, you name it. Women can be forced, they pointed out, to bear their rapist child or to bear children with devastating abnormalities. The dissent also noted that the results of this ruling will fall most heavily on poor women. Finally, Starry Decisis. The court laid out the majority, the 5 factors that are to be considered, and they are the nature of the error, the quality of the reasoning, the workability of the rule, disruptive effect on other laws, and reliance. The majority held that Roe was not only wrong, but egregiously wrong for the reasons I already discussed. It's not in the Constitution, it's not firmly rooted in history. It also said the reasoning was poor because the decision was sounded like a regulation or a statute. It held that Casey's holding that regulations that impose an undue burden was unworkable. The majority held, frankly, without any support, that Roe and Casey violated res judicata, ignored third-party standing. Well, that's a big issue because doctors and organizations came up as plaintiffs rather than the women, and it diluted strict scrutiny review. Now, the dissent disagreed on all factors, but the bottom line is that the concept of what is settled law is no longer viable, no pun intended. Apparently, settled law becomes unsettled when the composition of this court changes. Finally, what is next in reproductive rights? Will the morning after pill be banned? Will IUDs be banned because they interfere with implantation of an already fertilized egg? Will women and those who aid them be prosecuted for crossing state lines in order to obtain an abortion? Will in vitro fertilization be banned because some fertilized eggs will be discarded? Will women who spontaneously miscarry become the subject of a criminal investigation? Was it really a spontaneous miscarriage or was it an intentional abortion? We shall see. For now, there will be many laws passed both for and against abortion rights, and many will be challenged. What is clear is that women have lost the right to be equal citizens in this country, in that they can no longer make the choices that affect their lives, their family, and their careers. So like Damon, I'm angry. I hope it showed. These are my thoughts, my analysis, my reactions. Thank you, John.
Thanks, Judge. And to Danielle and Deepak, there's so many different things about these cases that are significant. I'll start with Dean Holley-Walker. What to you really sort of is the most striking?
You know, for me, it was, I think, the framing of Dobbs. If you notice, if you read the majority opinion and the dissent, it's like we're operating in two separate universes. The dissent really frames this, and I think the first paragraph of the dissent is the first time where we really hear about the rights of women, right? And the fact that the Dobbs decision firmly places women in a second-class citizenship framework as it relates to the US Constitution. Men in this country now have complete freedom, essentially under the federal Constitution, as to their reproductive rights. Women do not. And in fact, as Judge Schindlin just pointed out, to the point where a state could literally ban a woman from having an abortion under any circumstances. And our Supreme Court has now said that there is no protection under our federal Constitution for that. And to me, I don't see how a woman in this country and the people who value our rights could see this in any other way other than a complete step down for women in terms of the recognition of who we are in citizenship. And I think beyond that, we have to start to ask from a basic human rights framework. I think most human rights, in terms of what is recognized, would recognize the ability to control your reproductive freedom and reproductive rights as part of our basic human rights. The government being able to determine when a woman becomes a parent, I think, is beyond even what we think about in the federal Constitution, but is something that to me is untenable as a kind of tenet of our human rights framework. Obviously, we also have to be extremely concerned about Justice Thomas's concurrence, the notion that substantive due process does not exist, essentially, as it's been read. And he literally named off the opinions that he believes are now on the chopping block. Griswold for contraceptive rights. He named Lawrence for same-sex intimacy, and Obergefell for same-sex marriage. And if anyone believes that that is not the agenda of that court, of this court, I think you were sorely mistaken. They are headed directly into those areas. Also, even though Justice Kavanaugh, Justice Roberts, and others tried to reassure us they were not headed there, they are absolutely headed there. And I think the call to codify, right, which is a lot of questions about that, the call to codify many of these rights into federal law for Congress, that is going to be the next step, I think, in terms of freedom. But those are the couple of things that really struck me. I am beyond angry. I am, I feel like this is something that is an existential crisis for our Constitution, because if the Constitution doesn't protect basic human rights, according to the interpretation of these justices, there will be a need for a greater restructuring of our constitutional framework.
Deepak?
Oh, what to say? I think when the leaked Dobbs opinion came out, people read that and they thought, well, this can't possibly be the approach the court is going to take. This is, too radical, too sweeping. The idea that a constitutional right has to be, rooted in the nation's history and traditions from the founding, that leaves out so much of the American story, so much of the progress that I think people think of when they think of the Supreme Court. People still, or at least until very recently, thought of the Supreme Court as a symbol, as a lot of that progress. They think of Brown versus Board of Education primarily. They think of cases like Obergefell, and the methodology that Justice Alito is championing, he claims that it doesn't lead there. He claims this is just about abortion, but it's quite evident that the logic of that opinion is so sweeping that it would leave, most Americans out of the protections of the Constitution. And I can't help but think, when I think about this opinion, about what it means for the role of the court in our democracy. I mean, judicial review is something that really depends on public perception of the legitimacy of the court. Chief Justice Marshall understood this, right? That they were very careful about when to deploy that tool. And the court has always kind of followed as a lagging indicator behind public opinion. This is, a decision that is radically out of step with the majority of public opinion, and it is going to permanently change, and already has in a very short amount of time, permanently change the way Americans think about the United States Supreme Court. I mean, if people have seen the public opinion polling, even before Dobbs came out, the court was, at its lowest point ever in public perception, and it will only sink further. And I just, I don't know what that means for the rule of law, but I think that it's going to breed a lot of disrespect for the rule of law. We have never lived through a period of time where there was open defiance of the law because most people thought that the prohibitions imposed by the law were morally not sustainable. I mean, we didn't live through Prohibition, but during Prohibition, I think most people thought, well, those are stupid laws. We're not going to follow them. And so there will be, women across the country who will think, this law is morally odious. I won't follow it. I wonder what this means. I think we'll never go back. This fundamentally changes the way we think about the Supreme Court and the rule of law in America.
So we've had a whole bunch of comments in the chat and the Q&As. And I'm essentially going to pick one sort of set of questions. With respect to abortion itself, what do you think happens from here? Obviously there's been a lot of activity even since last Friday, but where are the big battles to come, do you think?
Well, one of the big battles is clearly going to be enforcement. I've been reading that public prosecutors in Texas are going to defy the law and saying, we're not any criminal prosecutions. Half of us are simply not going to do it. But like the country, where 26 states are going to outlaw abortion and 24 states are going to allow it, so is Texas. Crossover jurisdiction, and they'll bring it anyway. So it has a feeling of sort of open warfare between peoples, between states. There's so many issues coming up, and I tried to mention some of them, such as interstate travel and which right will trump which right. If you assist somebody to travel, and many employers have agreed to do that, law firms are doing it, employers are doing it, say, we will fund the travel of a woman who has to travel to a different state. But then are they open to prosecution? So I think there's a host of issues that are coming up under this terrible decision. And what frightens me is it just feels almost like another revolution, another violence, another civil war. I hate to see our country divided 25 states one way and 25 states another way, but that's what's lining up. The states that allow it are gearing up to provide access to women more than ever before. So that's one person's answer. I can't look forward to the other answers.
I'll make one observation, which is, just that I'm really interested to see the pivot now to state constitutional law and state courts. I mean, Justice Brennan told us back in the 70s, progressives need to pay attention to state constitutions as a source of rights. And we've seen this almost immediately. There was a judge, just after the decision in Louisiana that was based on the state constitution. And so there is going to be, an immediate move to see which states will recognize the right to choose in their state constitutions. I also think this will then change the way potentially people think about state courts. It may end up that races for justices on the state Supreme Courts will become polarized in the way that they previously haven't been. But I think that progressives have kind of been behind the curve on realizing that the state constitutions are an important source of rights. I also think that the court is wrong when it says that they are washing their hands of this issue and sending it back to the states. And so, this is just not a matter for the Supreme Court. There's going to be a slew of cases, and the judge hinted some of these issues. They will end up in short order in the Supreme Court, perhaps on the shadow docket. Once these issues about travel start to arise, there'll be issues about medical abortion. Can medical abortion, can the pills be sent across state lines? Will there be federal preemption of state laws? I mean, there's just a huge range of issues that this is going to open up. So if the Supreme Court is saying we're out of the abortion business, I don't believe that to be true.
And I think talking about the consequences, I always bring it back to the consequences for everyday people. That's one of the reasons why we are all in this as civil rights lawyers, is to positively impact the lives of everyday people. And I think what we're seeing is just mass chaos. So to talk about what is really happening on the ground, if you've been reading reports of women who are sitting in waiting rooms in places like Texas and other states who are literally seeking that kind of healthcare or seeking abortions and are being turned away literally in real time. But also, I think the number of lawsuits we've seen that have been filed and injunctions that have currently been put in place to stay pending laws that we see in places like Louisiana, Missouri, other places. So I think we are in a full state of just, chaos in terms of what the law is on the ground in many states. And each one of those will get a challenge. And some of them will happen under state constitutional law. And then we will have all of the other questions that will come up about interstate travel, et cetera. So I think having unsettled law, and what was ironic is that the majority said that Roe caused chaos and Roe caused dysfunction and Roe caused us to be pitted against each other. Clearly, I think having Dobbs will, if that was true, Dobbs will triple what they said was the division that was caused by Roe.
Thanks. So we could literally go on for hours and days in terms of talking about the abortion cases this term, but we're gonna move on to a couple things. It's clear to me there were a number of cases that we had prepped for this session. We're not even going to get close to getting through them all, but I want to go to an area that Deepak mentioned a couple of minutes ago. That's the shadow docket. And these are the cases that the court basically hears and decides without full argument, and frequently without an opinion from the court itself. And we're going to focus on three cases that Dean Holley-Walker is going to provide some analysis for. I'll give you some background on them. The first is Merrill versus Milligan. This was a challenger to the Voting Rights Act to the districts for Alabama Congress, and a 3-judge district court found that the districts and 2 of these judges were actually appointees of President Trump, found that there was a violation of the Voting Rights Act related to the failure of Alabama to draw a second Black majority district. The Alabama sought a stay from the Supreme Court that would allow Alabama to use these districts that the court found had violated the Voting Rights Act. The district court had found it violated the Voting Rights Act. Alabama asked the court for a stay. Alabama got that stay from the Supreme Court in a 5-4 vote. The court subsequently has decided it's going to take this case in the fall for a full argument, and the briefing of the case is happening now. The other two cases involve COVID and restrictions, requirements that the federal government had put out related to COVID. Both these cases were close, and they came out in different ways. The first being Biden versus Mississippi, having to do with participating facilities, medical facilities that receive Medicare and Medicaid funding, requiring that and staff of those facilities are vaccinated to COVID-19. And the court decided 5-4 that this was okay. And then the other case involved requirements under OSHA regarding employers that have more than 100 employees. And the issue there, I'm actually wrong about both cases, decided 5-4. This one's decided 6-3. And the court went the other way to say that this is something that OSHA could not require, or at least preliminarily, the court said this was something that OSHA could not require. Dean Holley-Walker, can you talk about these cases and more generally about the shadow docket and its significance?
So the shadow docket is becoming more and more important, as we've seen. And I think what Judge Schindlin said about women's whole health, it's becoming also a preview of things to come. And I think that's especially true when we look at the Alabama case, at the Merrill v. Milligan case, because we know that they're actually going to hear the merits of that case. It will be argued in October of 2022. So the shadow docket, just to be clear, and if you want to read more about this, I really recommend the Steve Laddick from University of Texas is writing a whole book on the shadow docket. These are cases where a party asks for emergency relief. They are typically, these are issued without anyone signing the actual opinion. There may be signed dissents that we've seen in these cases. They really have begun to emerge. And they're even, when we say shadow docket, many times the opinions will come out late at night when people aren't paying attention. And also we've seen this kind of rise in the shadow docket, particularly as to federal death penalty cases too. And the shadow docket has existed for a long time, but we're seeing a continued emergence of the use of it. I'll say in the case related to the Alabama redistricting plan, obviously the Supreme Court's action allowed Alabama to move forward in implementing a redistricting plan that was challenged as an illegal racial gerrymandering. And as John just said, this was not a decision by, a super progressive court. This was a panel of 3 judges, 2 of whom were President Trump appointees. So it was a kind of bipartisan appointee decision that this did look like it was an illegal racial gerrymandering that was being done in the redistricting plan, and they still allowed it to move forward, meaning that the midterm elections will be held under that plan. We're seeing this spread. Louisiana just had its own shadow docket case a few days ago, in which same thing, this is a question of the Voting Rights Act, Section 2, and the question of whether a redistricting plan should stand in Louisiana. The question was whether they should draw a second majority minority district, and that was put on hold, and now they will be allowed to move forward with the redistricting plan that does not favor African-American voters, which again will affect this midterm election. So some really important issues. As to Biden versus Missouri, and then our National Federation of Independent Business cases, again, we see a continued kind of pattern from things that we saw in Dobbs and women whole health. I think one of the patterns that we're seeing emerge in the shadow docket cases are really these questions of how the Supreme Court interacts with the executive branch of the government, right? And looking particularly at this question of, and many people are beginning to write about the Supreme Court as being almost a super legislature, right? So that things that would typically be seen as well within the range of what a federal agency can regulate. Now the Supreme Court is coming in and saying, okay, there's no regulation, or there should not be regulation in that area. So when we think about particularly the OSHA case in which they were attempting to regulate more generally what workers did, and the Supreme Court saying this isn't, OSHA doesn't typically regulate public health, they regulate conditions in the workplace. And when we think about COVID, that's beyond what happens in the workplace, but instead is really something that affects people in society generally. But again, the idea that in a shadow docket case, without full argument, without full opinions written, that they would make a decision that impacted millions of workers in defiance of something that a federal agency had decided they had the authority to do and were working under their own statute. Again, we saw a parallel in today's case on the EPA and the regulation of climate change. So the shadow docket is becoming what I would call a shadow preview docket of what the justices are really interested in doing in what we call the merits docket portion, the 60 to 70 cases that they hear every year on the merits docket. So keep a close eye on the shadow docket. And the Supreme Court is doing a lot of damage to civil rights in the shadow docket. And so it's really important for us to keep an eye on it.
Deepak, Judge, some observations about shadow docket in these cases?
So,
Yeah, well, I thought it was an interesting comment that the dean made about a super legislature. The court is acting that way. That's exactly what they accused Casey of doing, is acting like a legislature, and they're far worse. I'm glad you mentioned today's climate case. I know we don't have time to cover it, but this is again a harbinger of things to come in terms of delegation of authority to administrative agencies. I mean, they are pulling back our structure, our ways of doing things that we have lived with for a very long time. So watch out, because that's what's coming. Sorry, Deepak.
oh yeah, I would just say, I mean, I think that, you know, the shadow docket, you know, in some sense, as the dean mentioned, there have always been cases like this, but the court always used to have some humility and understand that when you're acting quickly, you don't want to be rash, you don't want to make new law. And so you're simply applying the existing law to a situation where you don't have a choice. The events on the ground are happening quickly, and so you need to decide. And what instead we now see happening is an activist court that is taking issues, and we especially see this ramp up in the pandemic, where they don't need to inject themselves, and where and you know, I think I agree with everything the dean said, where the court is getting very aggressive about you know, being entrepreneurial about constitutional law in these cases where they don't have the benefit of full presentation, of briefing, of oral argument. And the COVID cases, these vaccine cases, actually are an example where maybe the court heard the criticism, heard what Steve Vladeck and others have said, and they did actually set the cases for oral argument. So they're kind of a weird blend of shadow docket cases, and then these cases make their way kind of under the merits docket, but these opinions are very slapdash, and they're put out very quickly, and the reasoning is pretty thin. It's pretty difficult to understand the distinction between these two cases. Why is it that, you know, there was authority for nursing homes, but there wasn't authority for OSHA? The court just kind of italicizes the word occupational or workplace in the statute. And you know, so that is about the extent of the reasoning. But you also, as both the dean and the judge have alluded to, you also see a kind of preview of this earth-shattering development that we saw this morning, which is the rise of the major questions doctrine. So, you know, Justice Gorsuch in the OSHA case laid out his theory about this doctrine as a way of just kind of requiring very, very, very super clear delegations of authority to agencies before the government can operate. And it's just frankly a bit lawless, because it's in the eye of the beholder what is a major question. And so I just fear that it gives a license to any judge that doesn't like anything that the federal government has done to say, well, you know, this is a major question, and so we don't think you have the authority to do it. And I know we don't have time to talk about it, but just a shout out to Justice Kagan's magnificent dissent this morning, which everyone should read. And it's just about, you know, we should all be afraid about what this means for the effectiveness of the government.
Yeah, Justice Kagan, I think, especially saying, she predicted that we would all be textualists, but now she says textualism is only used for the cases that the justices agree with. When they want to overturn something like the EPA's ability to regulate climate change, all of a sudden they have a magical bag of tricks that gets them out of textualism. In this case, it's the major questions doctrine. But I think we're going to see more of that from the dissent. But going back to Deepak's point, it undermines the legitimacy of the Supreme Court. It is hard for people to believe in what the court is doing when justices on the court are having to say, we aren't following stare decisis. We aren't even following the most conservative tenets of statutory interpretation, like textualism. All of that is out the window in favor of just pure, unadulterated power. And people saying these are cases about power more than they are about the law.
And I want to pick up on one point that Deepak made. He said any judge could say this. Well, the point is that any judge on the lower court can be reviewed by a circuit court. What's troubling about the Supreme Court is they have the last word, and there's nobody to say otherwise because Congress is dysfunctional. In other countries, there's a time when the Congress can step in and basically overrule a Supreme Court decision. But with a dysfunctional Congress, our Supreme Court has become ultra powerful. And I think they know it, and that's why they're going after so many of our rights.
I'm going to add a couple observations, and on the case that was decided today, it's one thing on a going forward basis to say, okay, Congress, you've got to lay out everything specifically. But of course, what we're talking about statutes that were enacted a long time ago, and the court now saying, well, we're going to come up with a different understanding of what Congress now needs to do, and applying them to statutes that were passed in the past. I'm going to talk as a litigator for a second about the Shadow Docket cases and sort of how shocking they are, because what typically happens in these cases, and there are some exceptions to this, but oftentimes what happens is that the briefing takes place over a few days. I remember my first experience with a decision that was Shadow Docket like. It's actually had a major role in voting rights jurisprudence, is a case called Purcell. We had gotten a preliminary injunction in the Ninth Circuit, and Arizona asked the court to stay that injunction. And it was on a Thursday that we were told to file a response brief, and we had until Tuesday to file that response brief. We filed that response brief, and that was our only opportunity. And the court went ahead and created a doctrine, which was used probably 40 or 50 times in the 2020 election cycle, and now several times in these cases since, including the Merrill versus Milligan case. Another thing about the Shadow Docket is oftentimes there is no opinion. The court makes a ruling, it provides no reasoning whatsoever, and sometimes what you get is you get concurring and dissenting opinions, and you try to draw something from that. So I'm going to move on to the third case. And I know that Dean Holley-Walker is going to have to leave us in a couple of minutes. Probably won't be able to stay for it. And this is another big one from the term. It's New York State Rifle versus Epistle Association versus Bruin. This is the gun safety case coming out of New York. Challenge to New York's law that provided a lot of restrictions on people being able to have and carry a concealed pistol or revolver. And the question was whether this concealed carry law violated the Second Amendment. And it seems so long ago, but it was only a week ago that this case was decided. And by 6-3 vote, the court held that the New York law violated through the 14th Amendment, but violated Second Amendment rights to keep and bear arms. And I'm going to turn it over to Deepak to talk about that case.
So it's a mark of what a huge blockbuster term this is, that this is being treated as maybe the second biggest case in any normal term. This would be, the obvious blockbuster case. It's one of the most important decisions of constitutional law in decades. I think it is probably indisputably the most important opinion that Justice Thomas has ever written for the court. And it is really the triumph of a conservative movement to create this new right, and then to invest it with meaning through the power of originalism. Right, this is really the high watermark of originalism. If you think back to the Heller case in 2008, it announced an individual right to bear arms, but it didn't give it much content. It didn't tell lower courts how to do the analysis. It didn't tell lower courts what kind of tests to apply. And then in the McDonald case, a few years later, the court said that the right was incorporated and applicable to the states, but again, didn't provide much content. In the intervening years, the lower courts that heard Second Amendment challenges had adopted a two-part test where they would first see, is this within the scope of the Second Amendment right? And then if so, is there a burden on the Second Amendment right? What that meant in practice was that lots of gun laws were being upheld. Most gun laws were being upheld despite the existence of this individual right, because courts were doing, kind of traditional means end scrutiny of the kind we do with lots of constitutional rights. And they were finding that there were good reasons for the various gun laws that have been put in place. One of the probably the most significant thing that Bruin, this new decision, does is it throws that whole approach out the window. It says that the lower courts were all doing it wrong, and that is not the right way to analyze a gun law. Instead, you have to ask whether the gun law is consistent with history and tradition. And you have to become an amateur historian, and you have to figure out whether or not that law is sufficiently analogous, maybe not a mirror image, but sufficiently analogous to laws that were around at the time of the framing of the Constitution. That isn't even consistent with Heller itself. Heller itself said that there were laws like laws that prohibit mentally ill people from having guns, laws that regulate guns in sensitive places. Those things are not laws that existed at the time of the framing, but they were longstanding. They had some pedigree. And Justice Scalia, perhaps at the cost of getting Anthony Kennedy's vote, was willing to say in the majority opinion that those things are presumptively lawful. Now you have this strange situation in which, a whole range of gun laws are going to be challenged. And courts are going to be faced with having to do this kind of historical, analogical reasoning to try to justify laws that had previously been, unquestioned. And I think there's even, as I read it, a pretty big discrepancy between the court's majority opinion and the concurrence by Justice Kavanaugh, which was joined by Justice Roberts, because that concurrence describes what the court is doing pretty narrowly, as concerned with the kind of standardless discretion that New York's carry regime had. And it block quotes the part from Heller that says all these kinds of laws are going to be presumptively lawful. Well, how is that consistent with the historical methodology championed by the majority opinion? It's really hard to know. And I think there's going to be a lot of litigation about this fairly immediately. So the Supreme Court has basically invited, a raft of challenges, not just to these kinds of, laws about licensing of public carry, but of every conceivable kind of gun law. And I'm just not sure that the courts are equipped to do this kind of historical analysis. And there's going to be a big fight, I think, about the level of generality at which a comparison can be made. But even laws that are very, very broadly popular, where you have overwhelming support, red flag laws, all sorts of laws like the laws that recently passed. They're not necessarily laws that existed or analogs existed at the time of the framing. So it is a real triumph of the conservative legal movement. But I think a lot remains to be seen about how this is really going to operate on the ground when it comes to real operative legal rules. Up until now, Heller has operated a lot as a kind of political symbol, but without as much real purchase on the ground in terms of overturning gun laws. And that might be about to change.
Couple of comments. Yes, John? Okay.
Absolutely.
You talked about the time of the framing of the Constitution, and I'm glad you mentioned that, because when I did my Dobbs summary, I didn't make a simple point that I wanted to make, which is women had no rights at the time of the framing. Nobody was thinking about bodily autonomy, women's rights, women's equality, women in the workplace. I mean, women couldn't even vote. Women basically were the property of their husbands, let's be frank. So I wanted to just bring that point up, but more importantly, now respond what you said about guns. You know, we either have a fixed notion of the Constitution that never changes, or we have a living Constitution that has to move with the centuries. And, you know, we didn't have assault weapons. We didn't have magazines with a kind of multiple rounds that can shoot children in minutes. We didn't have that at the time of the framing. And so it really troubles me that we have this notion of, you know, whatever happened in 1782 or 1868, when 14th Amendment, whichever it is, it fixes it all. That's just wrong to me. And I want to make sure we talk about that. The notion that if we can't trace it back 200 years, it doesn't exist, whether it's Dobbs and women's rights or whether it's the guns. It's way beyond the words of the Second Amendment to leave it at that when we have when the world changes.
Well, and of course you add to that the circumstances that Black people in this country were in pre 1800 and others, and it's, you know, it's really sort of, it's I wouldn't say it's shocking that the 5 came out here. In this case 6 came out this way, because this so-called originalist theory is nothing new. It's been out there for decades. Originalism and textualism are things whose influence have grown over time, but we're seeing it manifest itself in ways that are much more dramatic than we've seen in the past, in both this case and in the Dobbs case. And in both of those cases, taking a very selective view of what the history is, and to think about the fact that, you know, here we are, what, more than 200 years later, trying to intuit what was going on, what the state of affairs was in the late 1700s and in the mid 1800s, which you know, in these contexts and others is often one of historical debate.
Right. So let me add, I'm a New Yorker, and I want to talk about this one more second. New York has already passed the law after Bruin came down. And it says, you know, public carries one thing, but we're not going to have public guns in hospitals, in schools, in other certain public places. They're testing these limits now, because we here ride the subways. Do we want the guy on our right and left to have guns? Do we want to have a fight about a parking space where everybody has guns? Do you want to go to Yankee Stadium where everybody's packing? I mean, again, talk about anger. This is a very, very dangerous opinion. And we have to think, I'm channeling Dean Holley-Walker, who would say, I want to think about regular people and what this means to regular people. As a New Yorker, this was our law, which had been around 100 years. And it's gone. And now we're told everybody can be packing everywhere, except our legislature just said not so fast. So again, we're going to see the follow-on litigation that will test the limits of these thoughts. And then one of the chats, I just happened to notice, our former co-chair, John Nona, said, well, we didn't have AR-15s. at the time of the Constitution. And that's the point. We evolve.
And this is just a couple of people have asked this question, just so you're aware. This is being taped. We will have it up on our website. We'll have some information on that. And then in response to an earlier comment that, again, is not specific to the cases we're talking about, but more general, we're going to have some continued discussions about these issues and others, other major constitutional and statutory issues that are going to be coming before this court, because they're going to be hitting hard. I'll talk a little bit about next term and what's going to be happening next term, that it's going to be another big term. You've got the affirmative action cases coming out of Harvard and North Carolina. These are cases in which the Lawyers Committee itself has been very involved. We represent students in both of these cases. We were successful in intervening in the North Carolina case, so we'll be a party there. And we're also very involved in the Harvard case, including arguing before the First Circuit in the Harvard case. The voting cases we've talked about a little bit already, that another major provision of the Voting Rights Act in the Milligan case is the court is going to be addressing the issue of vote dilution claims under Section 2 of the Voting Rights Act, but also this independent state legislature theory that we and others will be talking about in the time to come. And then in the sort of freedom of speech, freedom of religion front, as it affects civil rights, we have 303 Creative versus Alanus, where the Supreme Court will be addressing the issue as to whether or not businesses can discriminate on LGBTQ issues based on the business owners' religious views. And there are likely going to be other major cases that are going to come before the court. I mean, as we've talked about with respect to abortion issues and with respect to issues related to guns, the decisions that the courts issued in the last week are going to spur a lot of additional litigation is going to come out of those cases. And you can see some of those cases, particularly when state courts or lower federal courts strike down, in the case of abortion, strike down some of these laws, and perhaps in the case of on the opposite side with respect to guns, refuse to strike down some of these laws. Attempts by conservatives in those cases to get those cases up to the Supreme Court, get them up as quickly as they can, get them up on the shadow docket. So all these things, all these strands sort of come together in a lot of different ways that, we are probably looking at a blockbuster term again. There's one other case that Dean Holley-Walker was going to talk about that I'm going to address briefly, because I think it's a significant one. And then I'm going to give our panelists an opportunity to share some thoughts. I mean, we have answered some of the questions in the chat. Frankly, there are way too many questions to answer in the limited amount of time we have. And we understand both the concerns that people have, as well as just the overall anger and angst that we all have. So, but the case I want to talk about is Vega versus Tico. And look, for most of us during all or most of our lives, Miranda has been sort of a central principle in terms of the Fifth Amendment, in terms of police officers having to tell people what their rights are prior to engaging with people that have been arrested. This case isn't a criminal case. It came out of a criminal case originally, but this was a civil case that was brought after the criminal case. And the plaintiff in that case sent a claim for damages or brought a claim for damages under Section 1983. And the court, by 6-3 vote, found that you can't sue a person. A person cannot sue a police officer under 1983 for violating their Fifth Amendment right against self-incrimination by failing to provide a Miranda warning. One of the things that was shocking about that case is that the court said Miranda is not a constitutional rule. Instead, the court described Miranda as prophylactic, going beyond what it was that the Constitution required. And it seems to me that it certainly is an invitation for somebody out there to bring a constitutional challenge, or more likely will come up as a defense in a criminal case, in the hopes that the Supreme Court will strike down the constitutionality of Miranda. It's as we've been talking about, that what's going on in these cases, sometimes in majority opinions, but also sometimes in concurrent opinions, is invitations to bring additional challenges. So this has been a key factor of constitutional law for several decades. A couple of decades ago, there was a challenge to Miranda. There was a lot of concern that then, in a case called Dickerson, that the court was going to say that no, Miranda is not a constitutional right. But actually, in that case, I believe a opinion by Justice Rehnquist, the court actually did uphold Miranda in that case. Judge, there's one other case I want you to briefly address, not so much because of the significance of the case itself, but in terms of the issue of recusal. And that was the case involving former President Trump, where he was trying to prevent records related to January 6th from being disclosed, Trump versus Thompson. And the court found 8-1. It denied former President Trump's attempt to block disclosure of those records. Now, the one dissenter being Justice Thomas. And one of the things that we've learned in the months since is exactly how involved his wife was related to the events of January 6th. I briefly wanted you to talk about judicial recusal. I want to take advantage of the fact that you were a judge, and that you had to consider the issue of recusal. You were under certain constraints, and I want you to talk about how that's different with the Supreme Court, and share your thoughts on that.
Okay, happy to do that. I just want to make the point that the dissenter there, Justice Thomas, the only dissenter, said that a former president could assert executive privilege, and that he would hold that none of these documents should have to be turned over. Well, then we find out that his wife has been incredibly involved with the January 6th issues and wanting to try to overturn the election, doing everything she can. We further find out, I think, that he attended some meeting that actually furthered that goal. Now, the judges, the lower court judges, are bound by the Judicial Code of Ethics. So there's a statute that tells us if you own a single stock, you have to recuse. If you have a close relative on a case, you have to recuse. But beyond that, there's something called an appearance of impropriety, not just the actual impropriety. The case law has made it clear that if there's even an appearance of impropriety, you should do the right thing and recuse. And judges do it all the time. A judge in my former court just recused because she said, I have no conflict, but I can understand the appearance because at the time of the filing of the case, I owned a certain stock. I don't own it anymore, but I understand that. So judges, lower court judges do this, but the Supreme Court justices aren't bound by this, and they aren't bound by anything, and nobody is there to enforce it against them. And they sort of do what they decide to do. And so one goes duck hunting and thinks that's not a problem when they do it with the lawyer on the case. And one goes to these meetings, that's Justice Thomas, and he doesn't think that's an appearance of impropriety. Well, folks, as a former judge, let me tell you, there's a complete appearance of impropriety there with his wife's activities. I happen to be married. The things my husband did affect me too. That's a close family relative. And going himself to a meeting is completely inappropriate. So John asked that I comment on that. Happy to do it. There's a reason he's the only dissenter there who says not only could he, the former president, assert executive privilege, but I would find the privilege satisfied. He shouldn't have to turn everything over. Surprise, those documents showed White House communications with Ginny Thomas. So is he protecting his wife? Is that appropriate? But who's there to stop him? And that's the problem. We have sort of an unbound Supreme Court.
Thanks, Judge. I want to give the two of you a chance. I don't know if there's anything that you want to say to sum up kind of where we are right now, and really, appreciate. And I know that the people attending this webinar, just judging by the comments, really appreciate what you've had to offer for the last hour plus. But if you have anything that you want to say at closing, I want to give you a chance to do that.
Well, I certainly do. There's not much good to say about this term. There are one or two opinions we didn't get a chance to cover that might give you a ray of hope here or there. But overall, it was, as John started out by saying, probably the worst term in our lifetime in terms of depriving us of fundamental rights and changing our society, that these people should change our society in so many ways. So many of you, I was following the chats, sort of said, what can we do? Is there any chance of court expansion? Is there any chance of term limits? And those are the right questions to ask. How bold should we be in trying to, in some way, limit or bind the power of these individuals? Because we have this supermajority for a reason. It is no surprise to this audience how we got here. We all recall President Obama's nomination of Merrick Garland, and Mitch McConnell stopped it. We also all recall how fast Justice Barrett was confirmed. So we got here for a reason. It was a political reason. Our third branch has become politicized. It has lost the credibility that it once had. It has lost the respect of the people. How do we get that back? And so we have taken the position, this organization and many other civil rights organizations are willing to say something needs to be done. Can we get it through? Can it ever pass? That's a different issue. The way we're structured, the way the filibuster works in Congress, maybe not, but we need to try. So that's my summation in a short time.
I will just say, I have devoted the last 2 decades of my career to work before the Supreme Court. I, considered it an honor to argue before the court. This is a very difficult moment for people who do what we do and who care about the things that we care about, because, as I said earlier, I don't think any of us will be able to see the court the same way again. And I think, look, it's just people in a building, 9 people who all they do is they write things down on paper and they put out PDFs. The only reason that they have any power is because people respect what they do and respect the law. And that is a power that is developed slowly, carefully, gradually over time. And it can be squandered. I think the court is squandering it now. I think the Chief Justice is sort of stuck in the middle and understands that, but the justices to the right of him do not. And I think, we do live still in a democracy, or at least, in theory, a democracy. And so it's up to all of us to start thinking about the relationship between the court and the people and the democracy, and whether or not, you want to take part in the conversation about reforming the court. I think it is an institution that still has to be ultimately sensitive to public opinion. It doesn't seem like it right now. But there have been moments in American history where the court has changed because of a big backlash. And so this is not the time to give up. This is not the time to just say, I wash my hands of this. I think it's really important for all of us who care about civil rights, who care about the rule of law, to engage. So I hope you will. And it's really been great having this conversation with you and with Dean Holley-Walker as well.
And so I would just want to thank our panelists. I want to thank the group that helped put this together. I'm going to end in a similar place as where Deepak was, and what Damon said at the beginning, and that is, we're both angry, but we are not going to give up. We're going to be in this fight, and that's for the Lawyers Committee as an organization. Our board, all 3 of the panelists today are board members, as well as, I could tell in the chats, we had a number of board members and alums that participated. But for everybody on this call, it's going to be important to continue the fight. And like I said a little while ago, we're going to continue to do some things to keep up engagement on these issues, because the important issues here are just going to continue. There's going to be a floodgate of cases that we're both going to be involved in some form. As you know, for the conservatives out there, the court has basically said that we're open for business, and so for us, we need to do everything that we can to fight about that, to tell the stories of our clients, to ground them in the traditions of the law, and to make the most persuasive arguments. And of course, the law is just the lawyers are just one part of this. That this is going to require a societal movement to fight back against what's going on in the Supreme Court and other places right now. And really want to thank you for spending an hour and a half with us on a Thursday afternoon. I hope that this July 4th weekend will be a chance to both reflect and find some joys in life during this very difficult time. So thank you. And you'll be hearing from us some more. Take care.
Thank you. Thank you.